This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we are now joined by Todd Lutsky from the law firm of Cushing & Dolan. Segment's called Ask Todd because it's your chance to ask Todd your estate planning questions. So, get on the horn. Studio line here is 888-205-2263. That's the number to call if you want to ask Todd a question about your estate plan. Again, the number here is 888-205-2263. 2263. So pick up the phone, get calling, and we'll get to your questions as they come in. I'll ask the first question of you, Todd. How are you today?
I'm doing great. How are you?
Not great.
Uh-oh. What's wrong?
Daughter stuck her finger in a socket yesterday, electrocuted herself.
Oh, boy.
I had to ground her.
Oh, she's doing okay now?
She's been conducting herself better since then.
That's awesome.
Todd, I want to talk to you a little bit about the idea of leaving assets to beneficiaries.
Yes.
When we talk about the best way to do this, do you basically put the asset in a little basket, put a bow on it with a little letter, leave it on their front desk and their front step, and that's what you do? Is that the best way to do it, or not so much?
Yeah, probably not so much. I mean, I think it's strange that, we talk all the time about taxes. We talk about probate. I get it. Those are all important reasons to do an estate plan. We all know that. Protecting yourself from nursing home costs, another reason to do an estate plan. But there is a family behind the estate plan. These are your assets. And understand that I like to tell clients that the trust after you die can actually do more for you than it was doing when you were alive because of how you can leave the assets to the family. The bow idea, not so much, right?
Let's talk a little bit about some of the concerns that people may have and how different types of planning may help them. First and foremost, let's say that someone has children and they say, look, I want all of this to go to my children after I and my spouse pass.
Sure.
But I don't want them to get everything all at once. How can proper planning make that a reality?
And this is super important, especially for the folks that are planning that have younger children. And that's not uncommon, right? And by the way, you can set the age anytime. If you feel like they're not good with money and you want to get them to retirement, that's an option too. So let's assume you've got children and you're saying, you know what? If we die right away, a couple of things. One, if they're minor children, they can't own anything. Well, that's a reason to have a trust right there because I want the trust to own my assets, not some executor, not some guardian that we've listed. Number two, once they're in the trust, we can control how they get it. Like you said, Chuck, we can say, you know what? When you reach 25 years of age, make a distribution of 1/3 of that child's bucket to that child. At 30, he can have or she can have half the balance. At 35, they can have the final piece. Now, remember, before those ages, it doesn't mean that they're cut off. Before those ages, you have a trustee that says it can come out for health, education, welfare, and support. So, hey, the kid's going to prep school or the kid's going to college or, hey, make a distribution. If you've got those standards in there, then the trustee must make the distribution. He's in the hospital. Pay the bill. Now, the maintenance and support part is the gray area, right? That allows you the flexibility to say, all right, well, they graduated college and they need money for a down payment on their first house. That's a good reason. That seems like maintenance and support to me. Make the distribution. So you allow access to the money for good reasons and then big lump sum payouts as they mature, right? So it's a maturation process. So that's one very common way, but only one way. That's just the tip of the leaving assets to children iceberg.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you have a question for Todd about your estate plan, this is your chance to ask him your question live on air right now. The studio line here is 888-205-2263. 2263. So that's the number to call to ask Todd a question about your specific estate plan. We're going to take a quick break here, but when we come back, we're going right to your calls. So that number again is 888-205-2263. One last time, it is 888-205-2263, and we're going right to your calls when we return.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
All right, as promised, we're going to go right to your calls with Todd Lutsky. We've got space for one more call, actually, for Todd. So if you do want to ask Todd a question about your estate plan, call the studio right now at 888-205-2263. Again, we've got space for one more call. The studio line here is 888-205-2263. Let's go to call in number one. We've got Jeff in Lowell. Jeff, you're on with Todd Lutsky.
Hi, how you doing?
Very good, thanks. And you?
Good. I have a question for a life estate.
Okay.
I have a life estate set up. Can you change? You can change the names on that, can you? Or can you not?
So is your life estate, now this is important because many people set these life estates up, and there's really two ways in which they are set up. So first and foremost, when you set it up, did you take is it your house you're talking about, your primary residence?
Yes.
Did you deed your primary residence to your kids?
Yeah.
And then you reserve the right to live there?
Yep.
Okay. So now you're asking me, can you change the name of the children on that deed?
Yeah, technically, can you change that and put it into a trust?
So you can't alone. You're going to need your children's
they have
help.
to sign it.
Right.
Right.
So, and maybe you've listened in the past and you realize that I don't love this arrangement that you have here. And so
Right.
that if you wanted to fix it, my advice would be to set up a trust, probably an irrevocable trust, since I imagine you were doing that to protect it from the nursing home. I don't know why else you would do it. So,
Right.
so if that was designed to protect it from the nursing home, what you could do is set up a trust. Now, you can keep your life estate. Now, I don't know, how long ago did you do this? More than 5 years ago?
No, it's only been about 2, maybe a little more.
All right. So one, you can maybe undo it altogether depending on how old you are and just reset the clock because you haven't really lost that much time. Or you could set up an irrevocable trust, keep your life estate so as not to reset the clock for you, and have your kids contribute the house, the remainder interest that they have to that irrevocable trust. And now you, again, will really control both halves because as the trustee of the trust, you can kind of control the trust aspect, which is the remainder interest, and you'd still retain your life estate interest. So that might be a way of fixing it without resetting the clock and gaining way more control and protection over this house than the way it's set up now. So hopefully that helps for you a little bit. And you know what, folks? This is just one way you leave your assets to your children. Lots of people do this. I'm, again, not a huge fan of the life estate, but it does happen. I'm here to tell you that we have a new guide today that says how you leave your assets to your family, to your beneficiaries, really matters, right? Learn how the best way is to do it. Is sticking their name on the deed the right way to go? To me, I think it leaves too much control loss for you, creditor exposure for the children, your inability to sell it later. There's adverse capital gains tax problems with this arrangement. I don't love it. But again, you don't think of that when you say, oh, that's just how I'm leaving my asset to my children. You might have special needs children. You might want to learn how to skip generation tax issues. You might want to protect it from future divorces. Folks, learn how best to leave your assets to your family by getting the guide with the same name, 866-848-5699, or go to our website, legalexchangeshow.com. Once again, 866-848-5699 or legalexchangeshow.com.
Todd, we got another one for you. Jack in West Barnstable, you are up with Mr. Lutsky.
Thank you. My question is this. Is there a specific formula when you make out your will that would nullify any kind of contesting the will? In other words,
yep.
I have a family, and some of the members are estranged. They have been for 25 years. Do I have to leave them a token to avoid contesting? How do I go about that?
So great question. And you know what, folks? We talk about this a lot. No contest clauses is where Jack is going here. He was looking for that word. It's called no contest clauses. First and foremost, I would say to Jack, don't just do a will, okay? Because wills go to probate. They're a lot easier to contest and challenge. But doesn't matter. I mean, you can still put the no contest clause in the will, and you absolutely should. Even if you do an estate plan, we add no contest clauses to not only the will, but also to the trust. And we want that language, put in there. When do we use it? You absolutely use it whenever you don't leave things equally to your family. Like if you had children, you'd be leaving it equally to children, or equally to children and then grandchildren. If you're doing that, it's less likely there'll be a will contest. But whenever you leave things unequally, or certain assets to certain people even, put the no contest clause in. What does it do? How does it work? When you have that in there, it basically says that anybody who even files a claim to contest the will, never mind if they've won or not, just filing the claim to contest the will means that you lose everything you would have gotten in the will. Even if you win, you lose. So that's really what it's designed to do, and it really does work. It helps to keep, people from filing. Now, can you leave a certain token to children? Sure, you could. If you wanted to, you're always allowed to leave a little something, maybe that makes them feel good. Now, I know with second marriages, we run into this all the time, right? You want to hold the trust assets in trust for the benefit of that second spouse, but you don't want the second spouse to blow all the assets. You don't want them to lose it all, so you put language in there that said, obviously, no contest clause is very important to keep the kids from the first marriage at bay while we let the surviving spouse live. But then, ultimately, if you want, you can always give the kids from the first marriage a little something to tide them over, but still put the no contest clause in. I've done that in the past, and it's been super effective. Someone would actually, if they try, they go to another lawyer, and they say, I'd like to bring an action. But before they bring an action, the lawyer gets the documents and sees the no contest clause. The hope is that lawyer would say, probably not a good idea for you to file here. And again, leaving a little something to the kids from the first marriage to hold them at bay until the surviving spouse passes is also, a token. And again, you're going to see, if you read the documents, that ultimately when the surviving spouse dies, there's a likelihood anyway that these assets will find their way to that particular side of the family. So like I tell people, when you think about leaving your assets to your family, the trusts continue after you die. So many people think that when one spouse dies, oh, that's it, the other spouse just gets everything. No, the trusts live on, and these trusts can actually provide more benefit to the family after one dies than they can even when they're both living, especially in second marriage situations. So, Jack, add the no contest clause. Folks, anyone out there who leaves assets unequally to children, I advise you put the no contest clause in.
Paul and Methuen, we weren't able to get to you today, but give us a call back next Wednesday, and we'll see if we can get you in with Todd. Todd, thank you so much for joining us today.
Always a pleasure. Thank you.
The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com.